car crashes, defective products, dangerous drugs, injuries, and abuse. Across the state of Alabama, the attorneys, proudly sponsored by the law firm of Hollis, Wright, are here to serve you. Your tough legal questions answered by our experts with the attorneys of Hollis, Wright.
It is so good to have you with us. Welcome. You are watching The Attorneys. I'm Art Franklin. On this edition of The Attorneys, we are getting into a topic that is both practical and deeply personal. That's the financial implications of estate planning. As always, we like to remind you at the very beginning of the show that lawyers begin manning the phones at Hollis Wright to take your call. It's a free and confidential call, and the number is easy, 1-844-LAW-TALK. That's 1-844-LAW-TALK. You can reach someone at the attorneys right now and talk to one of the attorneys at Hollis Wright. Carter Clay is here. We've got a guest with us.
Yeah, absolutely. What's the expression about there's two certainties in life, death and taxes?
Taxes, right.
So we're going to talk about death tonight.
Okay.
So this show or topic will impact every single viewer that is out there watching the show tonight. In some way, shape, or form, at some point in their life, they will be impacted by the topic that we are going to discuss. We've got Lindsay Eastwood here with us to unpack this topic. And before the show got started, I was looking at some research on this, and it looks like about right now, about 1/3 to maybe 40% of the adults out there have a will, which means that the majority of the adults out there don't have a will. And so that's a sobering statistic from the standpoint that there are a lot of adults out there that probably have a lot of personal property and real property or real estate that they're leaving it up to chance in terms of where that property goes. And so I'm so glad we've got you here to talk about this subject.
Absolutely, and as the baby boomer generation sort of begins to age, I don't know if that percentage will go up, but it does seem very low, but I think it's in track with what I see in my practice.
And how long have you been practicing in this area of estate planning and estate litigation?
8 years.
Okay, wow.
And that's our exclusive practice area.
So you're all in on probate and estate, whether it be setting up wills and trusts for people or litigating these issues, heaven forbid there's a dispute amongst family members?
Yes, our firm actually has estates open in 56 Alabama counties.
Oh, wow.
So there's 67 total.
Yeah, you've almost got them all covered.
Almost.
You'll get there. You'll get there soon enough. Well, talk a little bit about just sort of a broad concept. When we talk about estate planning, I guess the best way to convey that to the viewers is, what do you do on a daily basis? We'll talk about estate litigation later, but in terms of estate planning, like, what does your day look like in terms of how you're helping people?
Sure. So I think clients frequently call the firm themselves. Frequently, it's the client who wants a will or wants a trust for themselves, or is sort of anticipating a surgery, or they are going to have a second child and they didn't have a guardianship nomination in a will for their prior child. So usually it's the client themselves contacting the firm and wanting to know what their next steps are. And we provide a series of worksheets that the client completes, and it's not just so I know how much to charge the estate, because a lot of estate planning attorneys will do estate work on a flat fee versus a retainer where it's billed per hour. So they provide that information about their assets and about their loved ones, those trusted people in their life, and then we'll have a consultation meeting to sort of talk through the pros and cons of different family members serving in different roles, what the implications may be if you leave out someone in a will or in a trust, what to do about someone who has special needs or potentially someone with a substance abuse issue. We talk through all of those things, and I discuss the sort of the pros and the cons of preparing a will and a trust, powers of attorney, living wills, healthcare directives, or what happens if you don't do anything.
Yeah, now I know cost and fees, legal fees that is, are always a big consideration that people have, and I know there's a lot that goes into this,
Sure.
a lot of variability here, but with just sort of a garden variety, bare bones type will, whether it's you or somebody else in your field of practice, what are the cost or fees associated with getting a will done?
I think a fair estimate for a will in Alabama, those are going to vary by geography. So if you're in Los Angeles, Bel Air, it's not going to be the same price as in Birmingham, Alabama. But I think $300 to $500 potentially for a straightforward will that doesn't have sort of like a testamentary trust in the will for minors would be fair for just a will, that $300 to $500 range. But it really varies based on attorney and experience level. There's also Legal Services of Alabama, and there are many other groups who, the volunteer lawyers, for example, with the Birmingham Bar Association, would prepare wills free of charge. So I think talking to community, potentially someone at United Way, could connect people with resources like that.
Well, and I wanted you to talk a little bit about the cost, because even in our practice, when we're dealing with our clients, whether they do or don't have a will in place, they're always like, well, I don't need a will, I don't have anything, or I don't have any assets. So really, you don't have to have that much to justify going out and trying to get a will, whether it's $500, $1,000, $1,500 to put together a basic will.
Right. I tell people all the time, I don't care if you have $50 in your bank account. You know, you need to go into the bank with your spouse if it's a joint account, or just by yourself if it's an individual account, and do a beneficiary designation. I will preach that gospel, you know, all day long, is that it's so important to have beneficiaries on the accounts, because it may have $50 in it now and it may be your slush fund to buy a spouse or kids Christmas presents, but then the next thing you know, you're depositing Social Security checks, or your RMDs from retirement accounts are going into that account. And then someone's calling me with a $5,000 or $6,000 balance. Hey, can you open this estate? And I'm going through the process of, well, this is how much I would charge. Would it be worth it for you to do, you know, to go through the summary distribution or estate administration process to get to that asset? Yeah. So you absolutely need to have those beneficiary designations.
Yeah, and as I listen to you, all the different fees, how do taxes come into play when it comes to estate planning? Are there strategies that can relieve that tax burden?
So that's a great question, Art. It's really different than estate planning in 2025 is very different than estate planning in the 1990s. You know, back in the day, when I was but a child, I was about 4 years old in 1990, but the estate tax threshold was so much lower. So it's $500,000, and I know that $500,000 is a lot of money, and when you adjust that per the Consumer Price Index, it would be more now. But now, in the state of Alabama, there's no estate tax, and federally, the estate tax limit is $13,990,000. And if you're married, that's times 2. So, Art, for most people, estate tax federally is not going to come into play for the actual assets of the estate. So what the house is worth, or what maybe in your Bitcoin, your Robinhood fund, your bank accounts, as long as you're under that threshold. But what could come into play if your estate is open for a long time, maybe you hire a lawyer who their specialty is not estate planning, or for some reason there's a lot of adversarial action in the estate stays open a while. Statutorily it has to be open 6 months, but if it sort of lingers on, then you may have to file what's called a 1041 estate tax return. We all file 1040s if we're W-2, you know, if we're earning income. But it's called a 1041 if that's an estate return. So if the estate is getting more than $600 in interest, you are paying income tax for the estate or the trust producing income. But most people don't need to worry about estate tax federally, and Alabama doesn't have it. Yeah, so if you move to another state, they may. Like Kentucky, I think, has it. Some northeastern states have it, and out west. But in the southeast, Florida, Georgia, Alabama, we're holding strong with no estate tax.
Before we take a break, talk briefly about the timing of how long this would typically take. I know you have to gather a lot of information, but you have the initial meeting, you're gathering the information. How long could your client expect it to take before you've got a finished product or a finished will for them?
I think you really want to try to turn that around in a few weeks. Okay. You know, I really don't think you want to go, you know, ideally longer than a month. From the time that you meet someone, you go over their estate assets, you go over the important people in their life. So you want to be asking for a consultation meeting, and then you want to follow up with what's the timeline for execution.
Yeah, so if anybody's out there ever dealt with lawyers, they know that 1 month is lightning fast when you're dealing with the judicial system and lawyers.
I think
that is a really fast time. But the point is to let the viewers know that this is not a long drawn out process to get a good solid foundational will in place. You may have to modify it at some point down the road, but it's not that time consuming.
I know you want to finish that point.
And in those emergency scenarios, Art, you know, there are lawyers like myself and many others in the Birmingham Bar and surrounding counties who would go to the hospital, who would go out to your home, who, you know, could make that timeline from 2 weeks to a month to, 6 hours if the attorney's schedule allows, because I think a lot of us are very sympathetic to those end-of-life crisis scenarios.
Lindsay Eastwood, why don't you put that bow on that right there as we were talking about that particular item. I want to let you know, though, that we've got lawyers standing by at Hollis Wright right now at 1-844-LAW-TALK, 1-844-LAW-TALK for a free confidential call for you. We're going to take a break. We're going to continue this discussion right here on The Attorney. Stay with us.
Here's some good information from our firm to you. Hollis Wright recently launched the Law Talk podcast. With podcasts becoming so popular, this will be a simple way to provide our loyal viewers with more opportunities to access information about important legal topics and to learn more about our firm and how we can help you if the need ever arises. There are many ways to access the Law Talk podcast. You can simply scan the QR code on your screen. Also, episodes are always available on the Hollis Wright YouTube channel, as well as on Spotify, Apple Podcasts, or wherever you consume your podcasts. Just search up Hollis Wright in the Law Talk podcast. Don't wait, take advantage and listen today. Thanks for watching The Attorneys, and we know you'll enjoy the Law Talk podcast.
The Attorneys, proudly sponsored by the law firm of Hollis Wright, are here to serve you.
When we started the show in 2011, my goal was to do what our firm does best. Help people answer questions related to real-world legal issues they have in their lives in a way that's not intimidating to talk with a lawyer. If the issue is important to you, it's equally important to us, and we're ready to talk with you at no cost.
Yeah, oftentimes people are confronting various legal issues in their lives that really run the gamut of a lot of different legal practice areas, such as bankruptcy, criminal law, civil law, such as personal injury, divorces, domestic relations. And to be able to have a show once a week that covers those practice areas and answers people's questions in those areas, that's really the main objective of the show.
We use the resources of the many lawyers at our law firm to create a plan that has a lasting impact for each person that calls or texts. And we also give back to the community at the same time. We are here to serve you, the viewer, each week on The Attorneys.
Addiction kills hope.
But at Bradford, it all changes here.
Experience the difference
that proven treatment can make.
Find recovery. Find community.
At Bradford.
Welcome back. You are watching The Attorneys. Wanted to remind you that throughout the show, you will see some information scrolling at the bottom of the screen. We like to make sure we share that topic information with you throughout the show. Also remind you to follow us on all social media platforms on Facebook, Instagram, and X. Good information there as well. Certainly good information with Lindsay on this program.
Yeah, absolutely. Lindsay, before we took the break, we've been talking about the development of a will. Now let's sort of fast forward to when the person that developed the will actually passes away. What can they expect in terms of the process at that point?
Well, hopefully, I feel like if the attorney has done their work and the person fully disclosed all their assets, they would not need to probate that will. You know, I guess a will, achieving a will's dreams would be to be probated and publicly available, in the Jefferson County Probate Court or whichever county in which the person lived or had real property. But if you've done all of your beneficiary designations correctly, you've resolved all of your real estate, meaning that just because I leave my house to you, Carter, in my will, upon my death, you don't own my house yet. You would have to probate my will. Someone would have to probate my will to be able to give you my house. So I think that a will may not need to be probated if all the assets are correctly distributed through beneficiary designations, through good deeds, or if it's held in trust. But if a will needs to go through probate, then you're filing a petition to probate the will, a petition for letters testamentary, and beginning that process with an attorney, depending upon what the will says.
So give us some examples or illustrate that point for us, because I think this is super important about designating beneficiaries and how that can help avoid actually having to go through the probate process.
Right. So I think a common example is with a retirement account. You have an individual retirement account, an IRA, or you have a 401k, and you only list your spouse on there because you're thinking your children are young and you're not thinking about adding them. And I definitely would not add a 2-year-old or a minor as a beneficiary of an IRA. You'd just be back in court trying to get a conservatorship or a guardianship done, at that point. But if you just name your spouse and time rocks along and you forget about that account, then that becomes a probate asset. And then you either need to probate that person's will, or if they don't have a will, you're opening up that estate. So making sure that you have a primary beneficiary on every account and a contingent beneficiary. And some of those assets it's not going to be possible to do that, right? If you have a great gun collection, or if you have a prized family grandfather clock, or your grandmother's ruby ring, you're not going to be able to beneficiary out those specific gifts. So you would want to put those in writing. If if heck or high water, you want whatever gift to go to a certain person, that needs to be in a will or that needs to be in a trust.
Right, but the point is that life insurance, you can designate the benefits of life insurance to beneficiary, and it goes directly to them upon death.
Exactly,
right?
Life insurance or a bank account, your checking accounts, your savings accounts, money market accounts, CDs, stocks. All of those are asset types that you can have a primary and a contingent beneficiary.
Yeah, and Art, a lot of times people don't understand when they're signing documents what all this stuff means, but when you buy a house, you and Michelle buy a house, y'all are probably joint owners with the right of survivorship.
Correct.
Well, those terms actually have meaning. What that means is if you pass away, Michelle is going to automatically get the house without the house having to go through the probate process, and it streamlines things significantly. It's a much easier way to pass certain assets. But Lindsay is right, because there are certain assets you can't designate a beneficiary: jewelry, gun collections, and things like that. So that's really where the will becomes important, and the probate process can become important.
And Carter, it makes me think about, the risks involved. Lindsay, if you don't have estate planning, can you talk about those?
Absolutely. I think it's a common misnomer that people think that the state of Alabama gets all their money if they don't have a will. I don't really subscribe to those theories. There's a set of laws that the state legislators in Montgomery, have decided what the general public, most people want to happen. But it's not that if you die, 100% of the money goes to your spouse. If you have children who are the same children of that spouse, then the first 100,000 would go to that spouse. And a lot of people would want their full estate to go to their spouse and not for the children to receive any of it if those were the same children of that marriage.
Well, and I think one thing that becomes problematic is if you don't have a will, the state of Alabama is going to provide a will for you.
Right.
And so what that can mean is if somebody's got a wayward child that abandoned their parent many years ago, moved out to California, didn't pay any attention to them. Well, if the parent does not have a will, guess what? The child that did care for you and loved you, they're going to get 50%, let's say, and the other child that abandoned you, they're going to get 50% as well, despite the fact that they left you. So the will give you control over where your assets will go, and sometimes it might surprise you, Art, that people don't have the best relationships with family members, and they'll have that control over where the money goes.
Right, and with the leader of the estate too, Carter. You don't just worry about who is the beneficiary of the estate. Some people may be fine with their 3 children having their estate in equal shares, but they know that one particular child would be a better leader in asset distribution and paying the debts and deciding division of the tangible property. So it allows you to choose the leader of your estate as well, and it also allows you to save some money, waiving a bond and waiving an inventory, allowing the personal representative executor to sell real estate without court approval. So a will, and a trust, those powers could be included, provide lots of benefits.
Now, you used terms administrator and executor a minute ago.
Yes.
Who are those people?
So that's really the leader of your estate. And I would say like the Willy Wonka golden ticket, in an estate are those letters testamentary or letters of administration. And people think it's confusing that it's a multi-page, Dear John sort of type letter, but really it's just a court certificate that empowers you to go to the life insurance company and withdraw the proceeds from an account that did not have a beneficiary. It allows you to go to the bank and open up an estate checking account. It really gives that person the authority. An executor is sort of an old term, but I still do use it some in the Alabama Code. It's referred to now as personal representative. So really no more executor, executrix. So it would be personal representative.
But the personal representative is the one that's appointed in a will, correct? And the administrator is a person that is appointed in circumstances where no will exists.
By the court. And they're subject to a bond. And you want that bond, it's not like you bond somebody out of jail. It's like an insurance policy to make sure that the administrator does not run off and buy an island in St. Lucia or something with the decedent's money.
If money or property does have to go through the probate process, what's the average time frame that somebody's looking at? And I'm going to assume it's going to be longer than a month.
Right. I mean, right now, those hearing dates, even to get a will heard, is like 3 months. So it really depends on the speed of the court that you're before, where that person lived, but statutorily it's 6 months, that you cannot close an estate before the claims period is run. And what is the claims period? Well, it's that time frame that a creditor, the American Expresses of our lives, the Synchrony Bank, those are some common ones that I see, Regions Bank, all these different credit card companies, or hospitals, if there's a hospital lien or an ambulance bill, those people can file claims against the estate.
And they have 6 months to basically file that claim from, I guess, the time the estate is open, right?
But you want to aggressively, or the publication, whichever is later, you want to aggressively defend the estate and object to those claims. You can save an estate hundreds of thousands of dollars by timely and correctly objecting to a credit card company's claims on an estate.
All right, well, that's going to be the question we're going to cover when we come back after the break, because I'm interested on the basis of how you can object to that.
All right, and we're going to take a break right here. We'll be back. Got just a little bit more time to finish up on this topic. Stay with us. You're watching The Attorneys.
Thank you for watching The Attorneys each Sunday night, where we come to your living room to provide free legal advice in a confidential, off-air setting. Unfortunately, with the number of calls, texts, and emails that come in during the show, we can't always get to everything. But know this, Hollis Wright is open all week long. You call us at 844-LAW-TALK and we're going to answer your question for free. Thank you for watching The Attorneys, and we look forward to seeing you and talking to you soon.
If this place could talk, it wouldn't. It would sing and celebrate all of our stories of addiction recovery, victory, and community. This is Bradford Health Services. It all changes here.
Welcome back. You're watching The Attorneys, and we're talking about the financial implications of estate planning. We've got Lindsay Eastwood with us. So glad to have you with us.
Thank you.
Yeah, Lindsay, before we took the break, we were talking about defending, the estate against claims made by supposed creditors that are out there, whether it's credit card companies. Talk a little bit more about the ability to object to those claims, even if they're made within the 6-month period of time, and how you can defeat those claims.
Sure. So there are several different, ways that you can object to credit card claims, but they're really not always about credit cards. They could be from several different types of creditors. But you have to make those objections in writing, and you would file that in the county in which the case is pending, and then you have to serve the creditor's notice of the upcoming hearing. And it's really a tight window. It's like a 10-day notice period. So from the date that they receive the notice of the claim, you have to serve them. So it's not just sending a letter to some random address hoping that this is the address for Citibank. You have to look them up on the Secretary of State's website, determine who their registered agent would be here in Alabama. And when I say you, I mean usually attorneys are the ones objecting to these claims. And then you would make that objection in writing. They would have the hearing. And in so few circumstances do the creditors actually show up to defend their claim. The claim has to be sworn, so it has to be correctly attested, and a lot of times those claims aren't correctly sworn. A lot of times the claims don't have supporting documentation or proof, like maybe the Home Depot Synchrony Bank is filing a claim against an estate for a Home Depot credit card, but they're not actually providing proof of the goods and services purchased from that. So you can object on those bases. You could also object on timeliness. But I find that just so few credit card companies and other types of debtor or creditors are willing to send a lawyer to Alabama to, defend this credit claim.
Yeah, well, it sounds like it's a lot of practicality involved here, because especially if the claim is only worth $1,000 or $1,500, are they really going to hire an Alabama lawyer or an out-of-state lawyer to come and go through this hearing process, because the money it may not make sense?
But if the estate is if it's a $40,000 estate, which is a significant amount of money, and that's someone's legacy, it's my job as an attorney to spend $300 worth of time and filing fees to get those claims absolved, hopefully before the court. And I would say that local credit unions are more likely to show up, and you just know that over time, having an experienced attorney who knows knows what creditors are most likely to appear in court.
Absolutely. Well, part of what we wanted to discuss tonight was estate litigation.
Yes.
So obviously family members can disagree or be upset about how the assets of their parent are being distributed. Do you see that in your practice from time to time?
Oh, I absolutely do. You know, people have cried in my office over, distributing a cuckoo clock and also some shrimp forks with a mother of pearl handle. But I think that the most common causes of litigation would not be those smaller examples, but lack of testamentary capacity, saying mom did not have capacity when this will was done. Mom had a dementia diagnosis, or mom was receiving morphine, for cancer treatments toward the end of her life, and she just did not have capacity. Also undue influence. And undue influence, it can be hard to understand, but caregivers can be accused of undue influence where the relationship is so close, that caregiver is in charge of, activities of daily living, those ADLs, helping the person get dressed, taking them to the doctor, preparing all their meals, all those sorts of things. And the closeness of relationship causes the testator or the person making the trust to be so overwhelmed that they feel this indebtedness that they would do something that they would otherwise not do.
Yeah, we see those crazy news reports, and even in movies and TV shows where the will is signed on somebody's deathbed and then they challenge it after the fact, or somebody is leaving all of their assets to the health and well-being of an animal to the exclusion of their 3 kids. But at the end of the day, how hard is it to prove lack of testamentary capacity, undue influence, mental incompetence? Like, what goes into all of that?
I think it can be hard to prove lack of testamentary capacity because there's kind of a lower threshold. There's some Alabama case law that says you could actually be inebriated and do a will, and that will hold up in court. There's also some Alabama case law that says that you can have a dementia diagnosis but be in what's called a lucid interval, and that will hold up in court. So, there's some ways that you can combat that if you're worried about your family fighting about your estate, and I think that's going to the doctor the same day that you do your will or doing your trust, so that there's a contemporaneous medical check saying, nope, I saw Lindsay that day, Lindsay had capacity to do that will. So that's one way to do it. Or meeting with a friend after lunch, a disinterested friend, so not a friend you're leaving your money to, but a neutral party friend who could have met immediately after the execution ceremony to defend against that.
Yeah, and that litigation process can be drawn out for months, if not years, to where you're getting into a year, 2 years, and there's a lot of expense involved in that process as well.
It really is, just like with the depositions, the cost of medical depositions of physicians. As you know, at Hollis, Wright, y'all are great at deposing physicians and other medical staff members, but you have to do them. You have to get the medical testimony to be able to prove your point.
Lindsay, great job tonight. We appreciate you being here. A lot of great information for our viewers. Thank you so much.
Thanks for having me.
Sure.
Yeah, good to have you. And hey, the show's ending already. We still have more to talk about here because we're giving you so much good information. So get more information by going to all of the Hollis Wright social media platforms, and you can find some good information there. Thanks for joining us. We'll see you next time on The Attorneys.
Thanks for watching The Attorneys, sponsored by Hollis Wright.